Welcome to the latest Evershed Sutherland Legal Insights podcast.
Welcome to our September edition of the Labour Exchange, our quarterly podcast on labour law and industrial relations. My name's Tom Player. I'm a partner and head of labour and industrial relations at Evershed Sutherland. Since our last edition of podcast, we have a new Labour government who have already proposed in their July King's Speech some wide-ranging and significant changes to employment law, but also importantly to trade union and collective laws, the most significant changes actually in circa 30 years. The government have proposed a new employment rights bill within 100 days of the election, and so in mid-October we should have the first look at proposed new legislation. These changes will significantly impact on trade union rights in the workplace, industrial action law, the rights of unions to organise collectively, and there are anticipated changes to statutory recognition and access rights. Today's podcast will address the trade union labour law changes within the new Employment Rights Bill, which we envisage will be contained in the legislation. I'm delighted today to be joined by my fellow partner, Emma Humphreys, to consider these issues. We know, Emma, that strike and industrial action laws in the UK require a lawful ballot and notification process. That's been in place within the Trade Union Act for many, many years, well established, quite complex in order for trade union members to participate in protected strike action or action short of a strike. So what changes do you think will come out of the government's upcoming legislative programme?
Thanks, Tom. So we obviously await some of the finer detail, but a couple of points we know for sure are going to be covered because the government have already confirmed that are the plans to repeal minimum service level legislation, which was brought in last year, which effectively put minimum service levels on certain strikes in some public services. And they've also confirmed that the ban on agency workers backfilling workers in sort of strike and industrial action scenarios will also be maintained. But so the sort of bigger question is around, well, what other changes are we anticipating? And I think what's been alluded to is effectively a repeal of the Trade Union Act in 2016, which listeners may recall brought in a number of changes to industrial action and picketing law, which effectively put in place further regulation on industrial action. So the new proposals would ultimately result in a deregulation of our strike law. The headlines being removal of ballot turnout requirements. So at the moment, there has to be a 50% turnout in order for a union to first get over the first hurdle of establishing a mandate. So that will be removed and would mean that trade unions would be able to secure a mandate on a simple majority of those voting. That has knock-on impacts as well for some of the additional thresholds for those in certain public services as well. It may also result in the removal of the 6-month mandate in place and instead potentially a return to the requirement that industrial action has to take place within the first 28 days of a successful ballot, which would then lead to an indefinite mandate for industrial action, provided that the trade dispute remains live. And then a further sort of key change would be a reduction in the time required for an industrial action notice. So currently it's 14 days that the trade union has to provide the employer, and we may well see that reduced to 7. There are other changes, but I think those are the key ones, Tom.
So a relaxation really of some of the strike laws, potentially making it more straightforward for the union to overcome some of the legal hurdles to get mandates and to give notice, etc. Thank you, Emma. That's really interesting, the overview that you've given on the trade union legislation potential changes. Can you just briefly outline how employers should begin preparing and thinking about these potential changes?
Yeah, so I think even now it's worth employers reviewing the state of their industrial relations, auditing their collective arrangements and how they're operating in practice. So, for example, does the dispute resolution process, is it fit for purpose? Does it provide a suitable mechanism for resolving disputes? Look at your IR risk level. What programs and projects have you got coming up that may cause potential a dispute? and audit high risk areas of your business from an operational perspective. So which workers carry out critical operational functions and would cause the most impact if they participated in industrial action, so that you can look at your contingency arrangements, what options are available, and what you can be doing now to prepare and put plans in place.
And can I ask you briefly, Emma, to comment on the suggestion of moving to e-balloting?
Sure. Yeah. I mean, the timing in terms of when that might come in is sort of unclear at the moment. So we're not expecting e-balloting in the employment bill, but we will be obviously watching this closely. But e-balloting is going to enable ballots to be organised much more easily and cheaply for trade unions. So that may well result in some increased balloting, subject to sort of comments we've already made. But it will almost certainly result in increased engagement in ballots, because it will be far easier for people to participate, via smartphone at a touch of a button. So I would anticipate then being a need for some consultation around that, particularly because there's going to need to be some consideration as to how to ensure that members are still protected in ensuring that their vote being cast is secret, and that sort of thing.
Okay, thanks, Emma. And I think you were going to fire some questions at me now, weren't you, on to do with the trade union recognition changes?
That's right. And I suppose we know, as you've already mentioned, that the government is sort of advocating for partnership between unions and business, and a sort of key strand of that is also simplifying the trade union recognition laws, which have been in place for quite some time now. But perhaps you can take us through what some of those anticipated changes are.
Sure. I think this is hugely important to the trade union movement. I think I'm old enough to remember when this law was introduced, and I was a young lawyer 25 years ago when the Blair government introduced statutory trade union recognition. It was a big thing for the trade union movement. Then it enables them to force a company that is reluctant to the table and agree collective bargaining as a result of a legal application to the Central Arbitration Committee. The law, though, is governed by quite complex provisions and schedules and requirements that a trade union must meet in terms of getting a mandate and support for statutory trade union recognition. It's those requirements which the Labour government have in mind. They're talking about simplifying statutory trade union recognition rules. That's essentially going to make it easier and to reduce some of those legal hurdles to secure bargaining rights. They believe in union representation and collective bargaining. It's core to the Labour Party and the trade union movement. And some of the things that they will do is we think that at the moment a union have to show a threshold support that the majority of workers in a bargaining unit would be likely to favour recognition to enable an application to proceed, as well as 10% membership. We think when this law is changed, the 10% test will stay, but having to show a majority would be likely to favour recognition will go. Also, at the point in time when a ballot is ordered by the Central Arbitration Committee to allow people to vote on whether they want pay bargaining or not, the union have to achieve a majority in the vote, plus that majority must also amount to 40% of the overall bargaining unit. We think that the government will remove the 40% test, so it'll just be a simple majority. There's also likely to be some tweaks and changes to the approach to campaigning. These ballots can often be quite controversial with employers and trade unions with very different views on employee engagement and representation. So they will want to control how those ballots are done as well. So the devil's going to be in the detail.
Yeah. And I think we know at the moment that the sort of proportion of sort of statutory recognition requests are pretty low in comparison to the number of sort of voluntary arrangements we know are out there. But so how significant are these changes going to be to potentially impact that? And why do you think they're so important for the trade union movement?
Well, recognition gives unions a package of rights. It's not just the right to negotiate on pay hours and holidays. A recognised union under existing legal frameworks has statutory consultation rights, has the right to appoint representatives and for facilities and time off the representatives. And those are rights that are not in place for unrecognised workplaces. So these are important rights to underpin membership levels, which are very important to the trade union. That's the main source of income in it to enable them to provide benefits to members. So it will help the trade union movement increase their significance and relevance, and will help them to achieve recognition in previously unrecognised workplaces.
Yeah. And I suppose linked to that as well, I understand that there are also proposals to change laws relating to trade union access to employers in order for them to recruit and organise, perhaps in completely ununionised workforces at the moment. Are you able to sort of take us through some of those access proposals and what that might mean in practice?
Unions generally don't have the right to access workplaces in an unfettered way to recruit and organise members, particularly so if you're dealing with workplaces where there is no current union representation in place. This new right would potentially give unions the right to access workplaces, and it seems to be talking about physical access. We don't know whether it would potentially involve some sort of virtual access as well, in order to recruit and organise. Now, this is likely to be a precursor to a statutory recognition or a voluntary recognition application. The right of access and the changes to the statutory recognition laws will enable unions to proceed and make voluntary requests for recognition as well. So it's potentially quite controversial. But the government are talking about introducing a regulated and responsible route. They're talking about transparent frameworks, clear consultation. So this is something that we're going to need to track carefully, and will probably be some consultation on over the coming months.
Yeah.
So just moving on, I'm also conscious that there's talk of fair pay agreements, Emma. Particularly in respect of the adult care sector. This would be a departure from union to company collective bargaining, which is much more common in the UK. Can you briefly just explain what that would be?
Yeah, as you say, it's a fairly groundbreaking and new approach to collective bargaining in the UK, and would effectively require collective bargaining at sectoral level between trade unions and employers to set minimum terms and conditions that are going to then be binding on all workers and all employers in that sector, and would almost certainly cover pay, minimum pay arrangements, but also potentially things like pensions, working time, holidays, approach to training. And at the moment, government's targeting adult social care for these fair pay arrangements in the first instance, at least. But we know that they have indicated that they may well look to sort of expand that more broadly.
Right. So it's a development of the collective bargaining model. Employers in that sector would be covered by these sectorial arrangements, and would represent a considerable shift. Interesting. And in other plans, do you expect changes to trade union collective rights more generally? I'm thinking so-called fire and rehire, facilities time, equality reps, these types of things.
Yes, absolutely. I mean, I think there's a wide package of rights and protections that the field, and dealing with sort of dismissal and re-engagement first. I mean, I think how that's been badged as that Labour will end the scourges of fire and rehire. It's not an outright ban, which was previously suggested, but effectively will mean that there will be far more limited scenarios in which fire and rehire or dismissal and re-engagement, effectively where employers are seeking to make changes to employment terms using that mechanism, that there will be a limited number of circumstances in which that will be able to be lawfully used effectively where there's genuinely no alternative to enable the employer's business to keep going and remain viable.
Yeah, and equality reps as well. Let's talk about having some equality reps as well.
That's right. So introducing a statutory rights for equality reps in workforces, also new rights of protection for reps in terms of protection from unfair dismissal, harassment and blacklisting. But it's interesting, I mean, these are protections that already exist to a degree. So it's to what extent that's going to be enhanced and further underpinned, and query whether we'll move even closer to the sort of protections we see from a perspective for those with protected characteristics. And also in terms of facility time, again, ensuring that there's going to be sufficient time for reps to properly represent and defend workers and negotiate with them in collective bargaining. So query again, may we see sort of statutory minimum requirements being put in place for that?
I'm just very, very conscious of time. I think you had one or two quick questions that you wanted to finish with, Emma, for me.
Yeah, so I suppose sort of looking at some of the longer term anticipated changes, and I know government's talked about introducing the right to recognition and unionisation for gig workers, and perhaps you can tell us just a little bit about that and the significance of that.
Yeah, I think this is on the long list. And the reason I think it's on the long list and won't be covered off in the Employment Rights Bill is because I think there is going to be a significant piece of work for the Labour government to look at worker status more generally. We obviously have a tripartite approach to worker status in the UK with self-employed, fully employed people, but also workers. And if you're a worker, you have some of the employment rights, such as national minimum wage entitlement and holiday pay, but not the full package of employment rights. Now they're talking about moving to a binary system, so just self-employed and employee, with workers effectively becoming another category of employee. Now, gig workers, who don't have that worker status are not able to organise collectively or apply for statutory recognition. And Deliveroo successfully defended a Supreme Court case brought by the trade union movement to challenge that. Now, I suspect that when we start looking at worker status over time, there'll be some changes to the statutory recognition regime to allow platform and gig workers to organise and to have trade union representation. And one other change I just wanted to flag before we finish is in the New Deal published by the incoming Labour government, they talked about expanding consultation on issues such as AI and surveillance.
Yeah.
I think there's a lot more to come on this in the future. I think if you look at the direction of travel from the EU in terms of corporate sustainability due diligence directives, etc., there is a requirement to engage with workers and worker representatives on AI and new tech, surveillance, etc. I think the government will inevitably look at this area over time as well.
Yeah, and it's interesting as well in that vein, we've got the TUC's bill looking at sort of AI in the workplace as well.
Absolutely.
Thanks, Tom. So I think that brings today's podcast to a conclusion. So thank you very much for joining us. It's fair to say that there is an awful lot happening and a lot more to come in the coming weeks that we're obviously going to be keeping really close to as a Labour team. So do look out for our webinars in our post-election series. It wouldn't be a podcast without a plug. So we know the 5th of November is already etched on your brains, whether bonfire night or polling day in the US, but it is also our Labour Relations Conference, which is taking place in our offices at Wood Street in London. So please do look in the show notes as to how you can sign up and join us. And lastly, it wouldn't be a podcast if we didn't say, please rate, review and subscribe, and see you next time. Thanks, Tom.
Thank you very much.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.